Thank you all very much. I'm Peter Smith, the United States Attorney for the Middle District of Pennsylvania. I think it's appropriate for the U.S. Attorney's Office to make a few remarks on this occasion. First, we want to say thank you very much to the jury. As the judge pointed out, they did their duty as citizens in rendering their verdict today and served their community and served their country well. The jury joined, I think, the vast majority of the community in rejecting the theory that corruption is the way things are in northeastern Pennsylvania, and that we have to accept the status quo as far as an alleged or purported subculture of corruption and thievery on the part of public officials. I'd like to also say thank you to the citizens of Luzerne County and the citizens of the Middle District, and including the press and the media, for their patience and attention during this long-term investigation and prosecution, and when appropriate, their constructive criticism of the investigative and prosecutive activities, and their understanding of the need, the absolute requirement that the government not disclose vast amounts of information out of an obligation of fairness to everyone concerned. The jury's verdict and the public sense of outrage expressed in the testimony and in the reports concerning this trial and these proceedings, I think, is an answer to those who maintain that corruption is the norm and that it's just part of the culture. It's a part of the culture that must change, and this investigation and this prosecution and the convictions, particularly the decision of the jury in the case today, I think put the lie to the claim that the culture cannot be changed. It simply must be changed. I think I have to call particular attention to the team of people who made the successful prosecution of the case today and the other cases related to it possible. This investigation began in the latter part of 2007, long before I held this office. It was a project, a team effort in the full sense of the word, conducted with the tremendous efforts of the Scranton office of the Federal Bureau of Investigation and agents of the Internal Revenue Service Office of Criminal Investigations, many of whom sat through the trial, participated in the trial, and worked long and intense hours gathering the evidence, interviewing witnesses, putting the case together, and making possible the presentation that you heard in court today. The public should be very grateful to those people. And I want to assure you that I am confident that they will continue to do the fine work that they demonstrated here. Next, I feel I must pay thanks to the staff of the United States Attorney's Office for the Middle District for their outstanding support of this investigation and this prosecution. Many of the people worked behind the scenes, but their work is absolutely essential to the success of the office, and I want to thank them. I think the community owes them a debt of gratitude, and it's comforting for me to be able to contrast their dedication and their work effort with some of the actions of the defendants in this case, as shown through the testimony in this case. I particularly have to call attention to the three gentlemen sitting with me and one gentleman who's standing in the back of the room. The gentleman in the back of the room is Chris Vasanik, the Chief of the Criminal Division of the U.S. Attorney's Office for the Middle District, who has been outstanding behind-the-scenes assistance to the trial team and to the office and to the public, especially in regard to many of the complicated legal issues that came up during the investigation, during all phases of the prosecution, and during the trial, and which I'm sure will come up during the appeal process. The gentleman who presented the case for the government so ably these past few weeks are sitting up here with me. I almost don't need to give you their names, but I want to personally thank Mike Consiglio and Bill Hauser and Gordon Zubrod for their tremendous sustained work as career professionals in this office in this investigation and this prosecution. The public, all of us, owes them a tremendous debt. It's a career staff that does its work day and night constantly, regardless of who the U.S. Attorney happens to be. In some cases against tremendous waves of apparent indifference and resistance, and yet they continue to do it. There was a writer who once wrote that justice doesn't get done in this world unless some very determined men and women make it their business to see that it is done. I feel I can say with full confidence that I've got 3 of those people sitting up here with me today, and I'm just honored to serve with them. And there are approximately 70 to 80 others comparable to them in the U.S. Attorney's Office for the Middle District of Pennsylvania, lawyers and support staff, and I want to thank them very much. I'd like to add a few more words that I hadn't planned to say with regard to the jury's verdict. The jury did its job, and we accept the jury's verdict. The defendant, and this should be remembered by everyone, has been found guilty of racketeering, one of the most serious offenses in the criminal code, originally intended to be aimed at thugs and street criminals, organized crime. It is no small thing, no light thing for any public official at any level of the government to stand convicted by a jury of the crime of racketeering, with its included predicate acts, which include accepting money unlawfully, as well as money laundering. He also stands convicted of mail fraud, violation of the Honest Services Statute, and of multiple counts of income tax evasion. For anybody to claim or to think for a minute that this amounts to getting off lightly, I would only call your attention to the number of months or number of years of sentence that he faces, as presented by Bill Hauser a little while ago in court. We accept the jury's verdict. We think the jury's verdict is an appropriate comment on the conduct of the defendant in this case, and we look forward to any post-trial motions and any appeal, and of course the further hearings that will take place in regard to the sentencing. I'm certainly happy to answer some questions. There are aspects of related matters that the office has still looking at, and I will not be able to comment on some things for which you have questions, but we'll try to at least answer some questions at this point. And if he can be coaxed, I think Gordon Zubrod may participate in this as well. Any questions?
Mr. Smith,
Yes.
The prosecution did not include too much of the so-called kids for cash angle, and Mr. Ciavarella and his attorneys say this is a victory for them because it shows that he did not sell kids to the for-profit juvenile detention center. How do you answer that claim by them that this is a victory for them?
Yeah. Again, I have to point out that I find it interesting that a man just convicted of racketeering is claiming any sort of a victory out there today. I wonder what he would consider a defeat. The investigation included a very intense review of the defendant's conduct as a juvenile court judge. And for a number of very good legal and evidentiary reasons, it was concluded that the facts and the evidence indicated by his pattern of conduct as a judge, while perhaps alarming to many people and of great concern, was not directly relevant to what was necessary for the government to prove, to meet its burden of proof in presenting the criminal case that was presented here. The facts of the Judge Ciavarella's conduct as a juvenile court judge are known. And we leave that to the appropriate state authorities to address. To some extent, it's already being addressed, and we hope it will be addressed fully, even constitutionally if necessary, as far as some resolution of the due process rights of juveniles is concerned. We're very sympathetic to the pain to the community that was caused here by the conduct of the defendant as a juvenile court judge, and we're fully aware of the deep anguish that many parents and many juveniles feel. But the federal criminal courts are not the appropriate venue to resolve that issue fully, and we leave it to the state courts and judicial bodies and even the state legislature if necessary to address it.
Mr. Smith, a question for Mr. Zubrod, if he's able. You just, with your help aside, you just successfully prosecuted, if you will, what many people consider to be the marquee corruption case that this area may have ever seen. What statement was sent today in your mind?
Well, when you look at the indictment, it alleged that the judiciary of Luzerne County during the tenure of Judge Conahan and Judge Ciavarella was a criminal enterprise. And I want to emphasize was. And we wouldn't have made this case without really fine public officials and very concerned private citizens coming forward and saying somebody has to do something about this. So in terms of a message, I think that the idea that this is business as usual in northeastern Pennsylvania has now been called into question. Because there are more and more people who are simply willing or not willing to corrupt it.
What is your take on the jury's verdict with respect to the $997,600 payment by Miracle? You know, the defense continues to say that the jury did not find that that was a kickback. Did the jury find that this was illegal money for him to have taken, that this was an illegal kickback from Miracle?
Let me give a general answer, and then Gordon or Bill or Mike can give a more specific answer. You heard the evidence in the case. Everybody heard the arguments that were presented on the forfeiture, and everybody heard loud and clear what the jury decided beyond the appropriate standard of doubt and unanimously. It appears from what you said that the defendant or the defense is continuing to argue, in effect, that this was legal money. That was stated pre-trial, it was stated at trial. We vigorously disagreed with it. We think the evidence disagreed with it, and it's certainly clear that the jury disagreed with it. And I think, generally speaking, I will stand with that. If Gordon wants to add to it, certainly feel free.
I can respond directly to your question. There was a jury instruction that related specifically to the honest services wire fraud. I think it was instruction number 6. And that instruction said that unless you find that there was a bribe or kickback, you must acquit the defendant. And this, the finding that this predicate act was found to have existed beyond a reasonable doubt is an indication that the jury determined beyond a reasonable doubt that in fact there was a bribe or kickback in connection with the honest services wire fraud predicate offenses in the RICO charge.
Mr. Smith, I have another question for Mr. Hauser, if
Go ahead,
possible.
sure.
Having Mr. Ciavarella on the stand admitting to the tax charges, admitting to the conspiracy to defraud the government, and then also being able to really pinpoint him on some of these other issues, what were you trying to accomplish there, and how was it to at least elicit some guilt from him?
I'd say it was satisfying. I have to say this, that cross-examination, a lot of preparation. I was assisted by Mr. Consiglio and Mr. Pizonik in that preparation. We prepared, I'm going to say, for 3 or 4 days for that cross-examination. That wasn't something that just happened on the spur of the moment. So in some sense, it was professionally very satisfying that I was the person who was able to do that cross-examination. However, I have to tell you that my colleagues were just as much a part of that as I was.
I would add that you just heard and saw a demonstration of what I mean by the team effort that was displayed in this case.
There are certain defendants, some who testified in this trial, some who didn't. Are they now going to be sentenced? Mr. Conahan, Mr. Powell, Mr. Miracle?
All 3 are awaiting sentencing, and I'll point out to you, if you'll indulge me, Mr. Conahan pled guilty to racketeering and has not yet been sentenced. No dates have been set as far as I know.
Will the government move now to push that issue to 76 people?
I don't want to comment on that. That's usually done at the discretion of the court based on a time frame set up by the rules and followed closely by the court.
I understand Mr. Conahan was willing to testify or wanting to testify. The decision was made not to have him testify. Any insight into that?
I don't think we can or should comment on anything regarding Mr. Conahan's not testifying, other than know that obviously he did not testify.
Mr. Zubrod, where does this case fall in your profession as far as significance?
Well, it seems to me that it has to fit into not only a career, but into addressing a problem that goes across the board. And so it is one step in that process. It's not the final process, and I'm guessing it's not going to be the greatest one, but it is one of a series that has been going on, a very intense series by the FBI and by the IRS and by our office from the late 90s on, to try to focus on, first of all, the connection between organized crime and public corruption, which is very real in this district. And then secondly, step by step, taking out each pocket where there is a power where people think they can't be touched. And so this is now the third judge that's been prosecuted in this case. And the idea, as some said during trial, that these people are powerful and can't be touched, I hope that's been broken. But the circle is much wider than that, and we need to keep going on.
In that vein, there was some testimony in the trial by some attorneys about conflicts of interest that Judge Ciavarella had in certain cases. It would appear on the taped conversation that Mr. Powell made some references to fixing cases and talked a little bit about a certain relationship with the developer. Is the government still looking at possible case fixing in Luzerne County courts?
I think it's best, for reasons that I've already mentioned at the beginning, for us not to comment on anything that may be ongoing or that we might be looking at.
Can you talk generally about what sparked this investigation, this prosecution of Mr. Ciavarella? We heard mention of late 2007. Was there somebody that came forward, and not to divulge all the secrets of your investigation, but somebody that came forward or checks that were passed that looked suspicious? What sort of element that we heard about in the case really sparked this whole thing and kind of brought it forward?
If you can, to the extent you can.
Well, as you mentioned, this has been going on for a while, the investigation. And the investigation really sprang from the Billy D'Elia investigation. About 6 or 7 of D'Elia's lieutenants were prosecuted. Ultimately, D'Elia was prosecuted. D'Elia led us to Judge Conahan, given his relationships with him. And then from there, it began, as we began to focus on them, the whole financial dealings between Judge Conahan, Judge Ciavarella, Miracle, Powell, all of that began to come. And you're right, other people did come forward.
County people, state people?
Yeah, both private citizens and elected officials who expressed concern as to what was going on. A number of them.
Mr. Zubrod, do you feel that the not guilty verdict on the bribery charge was maybe the result of the prosecution possibly falling short on proving quid pro quo?
Well, Zach, I think it's hard to speculate as to what a jury did, but I think the jury took very seriously the jury instructions about making a clear connection. And I think there was a very clear connection because you could go down to the nickel of who got what in the Miracle payments. I mean, we could trace it through banks. The cash, you could trace checks that went into the Pinnacle Group of Jupiter, but it was difficult to trace where that money went as it came out in the form of cash. We heard testimony about cash coming in, but you can't trace cash.
Sure.
And so I think the jury, it was not a conclusion that a bribery or an extortion didn't occur. It was, they were bending over backwards to be fair to the defendant and to make sure that they could trace the money before they nailed him down. And I think that's really what went on.
Sure.
They felt, not that he was innocent, but that the burden of proof had not been met.
Mr. Smith, we heard mention of the $997,600 that must be forfeited. Is there going to be penalty or forfeiture or repayment of the taxes that were not paid?
That'll be a totally different proceeding in which the IRS will go forward on as far as the collection of taxes and penalties and interest that will be owed. Any other questions?
Who's next?
Okay. No comment. Stay tuned. Thank you.
Thank you.